much. Colleagues, I'm going through this exercise so that we are able to record. It's really, I don't think it's proper for the portfolio committee that would have sent an invite on time to the department, and the department is here, and only officials are sent. And officials that are reporting to the HOD and the MEC. I think we need to record that. It's an observation that has been made. The MEC has for a while not been able to attend portfolio committee meetings. It's the first time that the HOD is not here. And I think, yes, we will accept the apology. But I think I'm sending a message to the officials that you send that message that the portfolio committee is not happy with the absence of the MEC and the HOD. It should not happen in the future. Yes, I'm going to hand over to the Chair of Chairs. This is the Chair of Chairs that I report to. And I'm happy he's here to observe what is happening as well.
Thank you, Honorable Chairperson Musai. Morning, everybody. Honorable members. I think just to add to what the chairperson of the session is saying, this session today, which is an important one, I mean, demarcation, the challenges that we have on the ground is immense, it's huge. So in essence, we have no real head here. The MEC is not here, HOD is not here, and unfortunately, the chairperson also got sick of the portfolio committee. So you have no real top management that are present here today. And I want to endorse what the chairperson is saying, that we put it on record that it is unacceptable, that it can't go on like this. We have to seriously, you can't leave the ship without or any vehicle without a driver. So I just want to also put that on record as the Chair of Chairs. Thank you, Chair.
Thank you, Chair of Chairs. Members, honorable members of the committee, do you accept those apologies with those remarks? Yes. Thank you very much. Let's move, sorry. If you can also introduce yourself, sorry.
Good morning, Honorable Chair. My name is Mr. Pillay from the city of Tshwane. We sent in apology for our city manager, Mr. Johan Matler, yesterday. He has taken ill. I'm representing the city at today's meeting. Thank you.
Thank you so much. Yeah, maybe I'll also give an opportunity to other municipalities if they also want to bring in any apologies. Will you introduce yourself?
Good morning, Chair and honorable members. I'm Solofelo Kopedi from the city of Ekurhuleni, HOD responsible for strategy and corporate planning. I'm with my colleague, HOD advocate Kemi Bihari, responsible for risk and corporate and legal. We want to render the apology of our acting city manager who's attending council today. Thank you.
Thank you very much. There's a hand there at the back. Oh, you. All right. Thank you so much. So you're the advocate. Okay. No, thank you. So I just want to do a roll call then before we really move. So we've got the city of Ekurhuleni, the city of Tshwane. Do we have Emfuleni? Thank you so much. The local municipalities, are they here? Can you also come to the mic just so that we note who's here? Please go ahead. seats.
Morning, Chair. My name is Jordan Pele from Lesedi Local Municipality, Office of the Speaker. I also want to render our apology from the acting MM, Mazondi, which is not able to attend. Thank you very much.
Good morning, Chair. My name is Mthunzi Mthwalo from Mfuleni Local Municipality. I would like to tender the apology of our MM. He is currently on study leave, and then our acting MM is currently held elsewhere in other meetings. Thank you.
Good morning, Chair. My name is Bila Chabalala, and I'm the Deputy Director in the Office of the Speaker. I would also like to render an apology for our MM. He's currently in another engagement. Thank you.
Sorry, which municipality?
Sorry, Midva Local Municipality.
Good morning, everyone. I am Tamrin Maine on behalf of the Mohale City Local Municipality. I do render apology also on behalf of the MM and EM as a result of their work commitment. I am appointed there as the legal advisor in the core litigation department. Thank you.
Thank you very much, colleagues. You can see the state of our municipalities. I can imagine why the state of our municipalities is in such a bad state. Colleagues, we received apologies for most municipalities where the heads are not here. I really want to employ and lobby this portfolio committee that we write letters to these municipalities, a stern letter to them out of this session where we are raising the disappointment that we have, and that really in the future, I think we can't allow such a situation. So members, with those apologies and those remarks, do we accept so that we can move?
Yes.
Thank you so much. So we're going to move to the next item on the agenda, which is the confirmation of the program. I'm going to request either the administrator or coordinator just to take us through that so that we are able to adopt. Colleagues, can we go ahead, please?
Thank you, Chairperson. The following items are on the agenda. The opening that has been done already, and declaration as well as the apologies, confirmation of the program. I'll open it from my side. And item 6 is presentation on the IMDA Bill. This will be done by the National Department of COGTA, Mr. Mate. And then we'll have inputs from all invited stakeholders, SCALGA, municipalities, political parties, SAMO, Municipal IQ, MISTRA, as well as civil societies. And then we'll have questions and answer session from members, and then vote of thanks. Thanks, Chair.
No, thank you very much. Members, can we have inputs on the agenda? If none, I would like to request that we have a move and a second. Member Ngobe.
Thank you very much, Chair, and good morning to honorable members, to the Chair of Chair, and to all the officials who have joined us this morning. Chair, I want to make a proposal on the agenda, bearing in mind that we have just checked on apologies, and we have identified a lot of gaps, so that we have proper coordination of the agenda, that we confirm, especially item number 7, Chair, on the stakeholders who are here, and the chronology of how they will be called to the podium, so that we know that we are working with a number of the stakeholders. Who are they, and what amount of time are they given each to deliver their inputs? I think that will help us in terms, not only in terms of coordination, but also in terms of time management. So I will propose that that be taken care of, so that we can then agree with this agenda. Thank you.
Okay, thank you, Member Ngobeni. Do we have any other inputs? Okay, maybe just to explain. Yeah, I've got a very soft voice. Thank you. Just to explain to members, we have invited, which I had already said, that we're expecting representatives from the SALGA, metros, the local districts, and political parties. Now, maybe at this stage, maybe I must just confirm which political parties are here. Earlier in the morning, I was informed that the IFP is here, but maybe let's just go around, or maybe we'll get the administrator to also confirm which ones are here. But the idea is that they'll all be given 10 minutes each to make a presentation. Can we get that confirmation? Who is here?
I can start, Chair. Action SA is here.
Umkhonto wesizwe is here.
Chair, the Freedom Front Plus is here. Thank you.
Okay. So I'm going to, when I do call out, I'll call them in that order. Those that have confirmed the way that they will, they announce themselves. So Action SA, IFP, ACDP, MKP, DA, and Freedom Front Plus. They'll all be given 10 minutes. We'll also announce when we get to the item. So, honorable members, can we have a move and a seconder for the confirmation of this program, please?
Thank you, Chair. I move for adoption.
Thank you, Honorable August.
Chair, I second.
Thank you so much. The program has been confirmed. So when we started, I was supposed to also outline why we are here. So before I give to the National Department, I just want to go through that. I think I got unsettled because we started late, and I can't pretend when I'm not happy. So, so the Municipal Demarcation Board is mandated in terms of Section 1553B and 1574A to determine municipal boundaries and to delimit wards independently. It has to take into consideration the supremacy of the Constitution. The powers given to the MDB are therefore emphatically stated in the Local Government Municipal Demarcation Board Act 28 of 1998, which must be applied in line with the provisions of the Constitution in order to ensure that the rights of the municipality, the municipal community concerned, are not infringed or violated by the decisions and actions of the board. So in terms of the Local Government Municipal Structures Act 117 of 1998, the MDB must determine the wards and publish its outcomes in the relevant provincial gazettes. Members of the public aggrieved by the decisions of the board are given 14 days to submit the objections. However, the undertaking of municipal capacity assessments by the board has attracted various dysfunctional meanings and understandings, primarily associated with the specific intended objectives and purpose. Honorable members, its design and scope thus varies from context to context notwithstanding understanding functional responsibilities and related capacities within municipalities holistically, and further responding to eminent challenges appropriately indicate a far-reaching objective. The undertaking of capacity assessments for the adjustments of functions and the determination of municipal boundaries in South Africa are premised on key pieces of national and local government legislative framework and policies. So these pieces of legislation and policies provide for criteria and procedures for the determination of municipal boundaries by an independent authority. This is also applicable for capacity assessment procedures needed for the adjustment process. In spite of this legal framework, there still exists a quandary regarding the usefulness of current assessments for municipal boundary adjustment, the adequacy of the prevailing assessment model, and lack of a sufficiently comprehensive framework for capacity-based adjustment. Therefore, experience has taught us that there are underlying weaknesses in terms of proper governance procedures or regulations that have been enacted to guide the functional adjustments and capacity assessments, public and stakeholder participation in municipal demarcation processes to date. So, ladies and gentlemen, it is therefore against this background that the proposed Independent Municipal Demarcation Authority Bill of 2022 needs to provide for the establishment, functions, and powers of the Independent Municipal Demarcation Authority. It has to provide for the criteria and procedures for determination and redetermination of municipal boundaries. It must provide for the delimitation of wards, provide for the establishment of the Demarcation Appeals Authority, and also to provide for municipal capacity assessments. It must also provide for matters incidental thereto. So I want to open up then that we request that we receive a presentation on this bill from Mr. Ntlamulo Mate to take us through from the National Department of COGTA.
Thank you very much, Chairperson, and greetings to the acting chair, as well as the chairs of chairs, and the members of the portfolio committee, as well as the official staff that are supporting the committee. And greetings to also our Gauteng provincial counterpart, and as well as officials from SALGA, and the relevant municipalities that are represented in this specific meeting, as well as the political parties, and SAMU as well, and other relevant stakeholders that are represented in this specific sitting. My name is Ntlamulo Mate from COGTA, under the branch called Policy, Governance and Administration within the functional unit Municipal Governance and Administration. I'll be taking you through this specific piece of legislation that is being proposed. I did, Chairperson, share with the Secretariat the presentation in case it might need to be projected. So in terms of how the presentation is structured, it's structured around, it provides the background as well as the structure of the bill itself and how the bill is configured. It also deals categorically with the clause by clause in terms of those provisions that are proposed in the bill, and it provides for the summary in relation to the demarcation and how the board should be undertaking the demarcation and various ward delimitation processes, as well as the inputs that we have received in the previous administration of Parliament in terms of what they proposed in the bill after it was introduced into Parliament. And it also deals with a recommendation. As part of the genesis in terms of where this bill has emanated.
Sorry, Dr. Mate, I just want to check. Are we not flighting, colleagues? Just wait a bit. We're not fighting, we're flighting. Thank you so much.
We can go to slide that deals with the background. Thank you. As part of the genesis in relation to where we come from, in relation to this bill actually tries to amend the current legislation that we have, which is the Local Government Municipal Demarcation Act. And of course, this was informed by inputs that we have received from the previous demarcation board, as well as the present demarcation board. And of course, also it was informed by the lessons that we have learned through the previous municipal boundary and ward delimitation processes, as well as some of the litigations that has occurred previously relating to demarcation impasse or community dissatisfaction in relation to some of the decisions of the board and the process itself. And we also learned from the inputs that we have received from the various stakeholders within the sector. And this bill is not the first time that it was made public. It was published in the Government Gazette in June 2020 for public comments. And we did receive those comments from the stakeholders and the members of the public. And that was also considered. We have held some internal workshops within the department with the relevant stakeholders. These include the MDB, IEC, SALGA, and the various sectoral departments and all provincial departments responsible for local government and other stakeholders within the sector. And due to the magnitude of the proposals that were made into the bill, this has necessitated that the current legislation, which is the Local Government Municipal Demarcation Act, be amended in its entirety and to be replaced by this new act. And this is not the first time, Chairperson, that has happened with the Human Rights Commissions Act, because there were a lot of provisions that were proposed. So that is not the first time that an act be replaced with the new one. But I would like to also indicate on the onset that it's not necessarily that we have changed everything that is in the bill. What had happened, we have strengthened various issues that I will be dealing with in the ensuing part of the presentation. So in terms of the relevant processes that we have undertaken as part of the legislative process, this bill was tabled before the cabinet previously during 2022 in the previous administration, and the cabinet approved that the bill be introduced to Parliament, and we did introduce the bill in June 2022, and we also complied with the rules of Parliament in terms of the introduction by issuing a prior notice of introduction in line with the rules of Parliament, rule number 276 of the National Assembly. And we also, after it was introduced to Parliament, it was tagged as a Section 76 of the Constitution's bill, which means that is the bill affecting the communities. Hence, it was referred to all the relevant provincial legislatures to undertake a public consultation. And the committee itself in the National Assembly, the COGTA Portfolio Committee in the previous administration, did also publish the bill for public comments, and they also extended that period to 15 June 2023, and it also conducted also the public hearings in all the provinces, and it also compiled a report, which report served together with the bill to the National Assembly, where it was submitted for concurrence and for consideration by the National Council of Provinces. And after it has reached the National Council of Provinces, there were some public consultation, public hearings that were undertaken in the previous administration. And while those were undertaken, other provinces felt that perhaps because we were in the period straddling between the national and provincial elections, so they felt that other provinces felt that perhaps there was no sufficient public consultation because the time was so limited that they did not have that time to conduct adequate public hearings. So they needed to have an opportunity again to also conduct a thorough public consultation. And then this bill was now revived in the new current term of Parliament in the 7th administration, and it was now referred, it was deliberated upon. We did brief the National Assembly, the National Council of Provinces in the current term, and then they had their own deliberations as well, and they had also resolved to refer the bills to all the provincial legislatures, hence we are here. So in terms of how the bill is configured, the bill provides for the definitions in Chapter 1, as well as the purpose of the Act, as well as in Chapter 2, it deals with the operational activities or administration of the board, which includes how the board determines its own staff establishment and manages its own finances. And then Chapter 3 deals with the primary responsibilities of the board, which include determining a criteria for determination or redetermination of municipal boundaries. And part of the main drivers of this bill was to try and maximize public participation. So we've dealt much in strengthening public participation inside the bill. And also we also established what we call the Demarcations Appeals Authority, which we've never had before. I'll deal with it in detail in the proceeding part of the presentation. Then Chapter 4 deals with municipal capacity assessment, as the whole chapter on municipal capacity assessments. I think the chair also reiterated a lot about the municipal capacity assessment. I'll deal also with that in the ensuing part of the presentation. Then 5 deals with miscellaneous issues, just empowers the minister to promulgate regulations and to issue guidelines to facilitate the implementation of this act, and as well as penalties and transitional arrangement measures and amendment of certain provisions, which I'll deal with in the latter part. So, as the long title, before I deal with the long title, let me deal with the renaming of the bill. We've considered renaming the bill now, the act now, from the Demarcation Act to indicate that it's an independent municipal demarcation authority bill, which will be an act after enactment. And that was to try and align to the provisions of Section 155 of the Constitution, since it provides for a national legislation to establish a criteria and procedures for the determination of municipal boundaries by an independent authority. Hence, we needed to align that to the renaming of the legislation. And then in terms of the long title, just to reiterate, as the chairperson has also dealt with, the bill provides for the establishment of the Independent Municipal Demarcation Authority, as well as setting criteria and procedures for the determination and redetermination of municipal boundaries, deals with what delimitation, capacity assessment, and the establishment of an appeals authority. So in dealing with the clause by clause, clause 1 deals with the definitions. So these are the definitions that are assigned into the bill, which are the new definitions as it relates to the Act. So clause 2 deals with the purpose of the Act, which is to establish the Independent Municipal Demarcation Authority and setting the criteria and procedures for the determination of municipal boundaries. And then 3 deals with the establishment of an authority, because in the present legislation there is that misinterpretation in terms of how we relate to the board. It's like the board is independent from the authority, the MTB itself. So we needed to draw a line to say that the authority, like when we call the IEC, we don't insulate the commissioners from the IEC. So the IEC is the entire organization. So we needed to have something like that to say the authority will include the board and its administration, so that there is also alignment with other constitutional institutions. And then 4 deals is just clarifying the status of the board to indicate that this is also a constitutional institution and is independent and must perform its functions without fear or favor or prejudice. And then 5 deals with the functions of the board. What we've added there was to compel the board or making it a mandatory requirement for the board to conduct municipal capacity assessments, which I'll deal with when I reach to that chapter. Then 6, we're saying that the powers of the authority, we're just clarifying the power of the authority as a constitutional institution to say that the powers is being conferred to the authority in terms of this legislation, and that the board may also now determine as an independent authority its own staff establishment, including the appointment or filling of vacancies within the board, the institution. What is interesting here is that communities felt that the board is far from those communities within the provincial, at the provincial level, and others would feel that the board is just sitting in Pretoria, trying to draw lines or geographical boundaries without having been closer to the community. So what we've done is that now the board can acquire building and also have the offices like that of the IEC, so that it can also have the provincial offices in all the provinces, of course having due regard to the financial resources that may be appropriated through the appropriation in the National Revenue Fund. So 7 deals with the composition of the board. Here there was also a misinterpretation, others construing the composition of the board to mean that these are the people or individuals coming from all of the 9 provinces, proportionally represented in the board. So, and that was not the intention of the Act. So what we've done here was to clarify that the composition of the board must broadly reflect the composition of the South African society. So it doesn't have to mean that it's individuals coming from each of the provinces to form the board. So 8 deals with the responsibilities of the board. Here we're just saying that as an independent authority, the board is responsible for corporate governance of the authority and may also exercise their powers and functions in line with this legislation. So 9 deals with the qualifications of the board. We've added over and above those qualifications that are prescribed in the Act now, because the work of the board involved the intense use of the information communication technology. So we said that for a person to be eligible to be part of the member of the board must also possess the knowledge around the information or qualification around information technology. So clause 10 deals with the appointment of board members. For oversight, we have indicated that over and above the presiding panelist, that selection panel for the members of the board, we needed to have the chairperson of the National Assembly to be part of the selection panel, so that there's also oversight on the side of the legislature. And because the drawing of municipal boundaries also revolves around the geographical lines of traditional authorities, we've said that the chairperson of the National House of Traditional Leaders and Khoisan leaders must also be party to in the selection panel to select the board members. There's a lengthy list in clause 9 in terms of that selection panel. So we're saying over and above that, for oversight, we have the chairperson of the National Assembly, and also we have the chairperson of the National House of Traditional Leaders and Khoisan leaders to be party to. 11 deals with the term of office. What we have done now is that in the current legislation, the term of the demarcation board is 7 years, and a trump to that of the municipal council. So we needed to ensure that there's alignment, so that the board that is appointed is responsible for the entire cycle of that municipal ward boundary redetermination, so that they are also accountable in relation to those decisions that are made in ward delimitation. So we align that to that term of a municipal council. At least it ends 6 months after the term of municipal council, so that they can start with the new, not the old board having to hand over some of their redeterminations to the new board. So the accountability might derail if we don't align that. And we're saying that a member of the board may not hold an office for more than 2 consecutive terms. You will see that this is also aligned. You will know that the premiers and the mayors may not hold the office for the period longer than the 2 consecutive terms. So we're trying to align that as well. So one other thing that we have, part of the intervention was to ensure that if a board member is absent for a meeting without having been granted a permission from the chairperson, so if he does so, he will be deemed to have been ceased to hold office, because part of the reason why they are appointed, they are there to make those timeless decisions, and they are remunerated for that matter. So we're saying that a member of the board cannot just be that he is absent without having been granted such a permission from the chairperson. So we're trying to deal with the code as well. 12 deals with the conditions of appointment of the board members. Were saying that the conditions of appointment are finalized by the Minister of COGTA in concurrence with the Minister of Finance. And then in 13 is the appointment of the chairperson and the deputy chairperson, who are just empowering the president to appoint one member as the chairperson and the other as the deputy chairperson, so that in the cases where the chairperson is not available, then the deputy chair can be able to perform those functions, so that we ensure that there's continuity in the work of the board. So clause 14 deals with the meetings of the board. So we're saying that if the majority of the members, because these are 10 members forming the board, if 6 of those members so request that there must be a meeting, surely there would have been a need that such a meeting should be held. So we're saying that the chairperson must convene that meeting if it's requested by the majority of the members. And that, so that if they constitute a quorum, so they will be able to conduct that meeting. And if the votes tallies becomes equal in those 10 members, we're saying that the chairperson must also have a casting vote to ensure that decisions are timelessly made, so that we don't reach a deadlock. 15 deals with the rules of procedures. We're saying that the board must determine its own rules of procedures. Like any other house, we all have rules that we live with. Like the committee itself has its own rules. So we're saying the board, as an independent authority, must also determine on its own rules in terms of how it deals with internal processes and procedures, in terms of how it conducts its meetings. And we're saying that they must also keep records of those meetings, so that they must also be accountable in case where some of the matters ends up also in court. The records are necessary for that purpose. 16 deals with committees. 16 and 17 we're saying that the board is empowered to establish the committees that are necessary to enable it to perform its functions. So they can have those committees, and because some of these redeterminations might require some specialized skills, so they are empowered to be able to have those committees to assist the board in those maybe investigations or municipal capacity assessment, whichever case may be deemed necessary by the board. So that is to empower the board. But we're saying while the board may delegate those responsibilities, it may not delegate the responsibility to make a final ward boundary changes. So that must reside with the board. The decision must be made by the board, not the committee of the board. Then 18 deals with the conduct of members. We're saying that as an independent institution, if a member is appointed to the board, he or she must perform the functions of office in good faith and without fear, favor, or prejudice, and must disclose all of the personal or private business interest And if the member fails to do so, may be deemed to be guilty of misconduct. We're trying to deal with the code, and given the nature of the board, we're also trying to avoid the influence or that may come. It may be a political influence or any other related matters or political expediency or gerrymandering in what delimitation process is. So then 19 deals with the, because the present legislation provides for a manager. You will recall that when we promulgated this legislation at the time, it was during that dispensation process. So the PFMA came later, the public finance management came later. So we referred to the CEO as the head of the administration, but it's referred to as a manager. So we're saying to align to other constitutional institutions within that end term so that we should not enter also into constitutional crisis. We're saying that here, if the minister publishes that formula, and then the board must also, the request for redetermination may not be done during that period, or to avoid disruption in the program towards preparations for elections. So that can be attended later after the elections. Then 27 deals with the notification for redetermination of municipal boundaries. We're saying here, if the board wants to redetermine an area, it must issue a notice indicating its intention to determine a certain boundary so that communities are able to see or partake in the process. So the community will be allowed to have 13 days to submit written submissions. And we're saying that because there are those other targeted institutions, so we're saying that the minister must be informed as well. There's a targeted audience to be worthy to be consulted if there's a change in a municipal boundary or what delimitation. And we're saying the MEC for that province need to be also be aware, made aware of those redeterminations. SALGA, as well as part of organized labor, must also be consulted, including the affected municipalities. And we're also saying that since the change in municipal boundaries also revolves around the magisterial boundaries, so we're saying that the magistrates must also be consulted in that process. And the traditional leadership within all the levels must also be consulted because the change in the municipal boundaries revolves around the geographical areas of the traditional and Khoisan leadership. So we're trying to broaden the process in terms of the consultation, so as we're trying to maximize public participation. So to avoid a situation where a traditional leader would say his areas were some of his areas are excluded, and he was not made aware of that. So we're avoiding those extenuating situations. Then 28 deals with the conducting of a formal investigation. We're now compelling the board to conduct formal investigation because there had been some outcry. Others will say the board is sitting in Pretoria drawing the lines through the computer and plug that into the community. So we're saying the board now must conduct formal investigation, including visiting that area, physical verification, taking into account the physical features of that area before they can redetermine that municipal boundaries. Unless if it's a technical minor adjustment in nature, so it's not something that may be causing a problem. So then 29 deals with the public consultation. So here we're saying also the notice must also be published in the local newspaper if there's a meeting. For those meetings that must be conducted by the board to inform or to ensure that the information is disseminated within that area that the board intends to redetermine. And they can also do so using any other means of communication that is prevalent or used in that area, so that communities are able to partake in the process. Then 30 deals with the mechanism and procedures. So here there are provisions in the Systems Act that provides for the mechanisms and processes for the council. It compels or makes it a mandatory requirement for municipalities to establish appropriate mechanism for community participation. So here we're trying to say that the similar provisions applies to the board as well. It must also determine those mechanism for public participation, so as to try to maximize public participation. And we're also saying that the public participation may also take place in the government buildings, and also those community-based organizations must also be informed when that boundary is redetermined. And we're saying that because these legislations, when were enacted as well, we did not take into account that there will be some development in terms of the technology, and now we are in some sort of sophisticated technological advancement. So we're saying that the community participation may also take place in the sort of virtual platforms as part of the other additional measures that may be, mechanisms that may be used to conduct public participation. Then 31 deals with the objections as well as the publication of the final boundary determinations. We're saying that before the board considers a final ward boundary, it must publish that into the provincial gazette for comment, so that the committee can be able to see how is the boundary changing, so that they can be able to have comments if they feel that the final word, it might affect them, so that they don't become surprised when a municipal boundary now is changed and they were not really aware how that changes. And we're saying that when the board makes final decisions, it must also provide or publish in the website the reasons for its decision to determine a certain boundary. We're just trying to ensure that there's transparent process and that the community as well is aware of what were the compelling decisions that has resulted in the change in their area. So 32 deals with the board, because there are other concurrent process that must be undertaken by the IEC and the MECs after the board has concluded with the ward delimitation processes, because this is done in preparations for elections. So the IEC might have to issue the election timetable, and the MECs must also publish certain notices, such as Section 12 notices in terms of the change in the name of the municipality, type, and how it's configured. So we're saying those, after the board has concluded, must hand over to the IEC and the MEC to also comply with those requirements in preparations for the elections. And then 33 deals with the board having to publish also. We're making it a mandatory requirement now that the board as well, just like the IEC, having to publish the election timetable in terms of how it's going to conduct the elections. So we're saying the board must also publish same to ensure that communities and people are aware of the timelines of the board. And we're saying that the board may not change that timetable after it is published in the Gazette unless there are any other extenuating situations. This may be that because the work of the board in nature that can interject with the work program of the board, then in those exceptional cases and through the good cause shown, the board can change the ward delimitation timetable. And then 34 deals with the number of wards. We're saying that the number of wards of ward councillors must be equal to those that would have been determined by the minister, so that there's alignment in terms of the number of councillors. 35 deals with the criteria for delimitation of wards. Here, because the current legislation allows for the board not to vary may vary by not more than 50% of the norm when they determine a ward. So we're saying that because at point there are splitting of farms and to avoid a situation where we have a building falling in one municipality and the other side to the other. So in those exceptional cases, we're saying that the board at least may deviate by 30% in those exceptional cases so that they can be able to cover those areas if for any reasons as may be deemed necessary. Then 36 deals with public participation. So there's the similar process that I've outlined in the preceding part of the presentation also applies. So 36 to 37 deals with the similar process, but that being applicable to the ward delimitation process. So it applies to the major redetermination and also in the ward delimitation processes. Then 38 to 46 deals with the establishment of the Demarcations Appeals Authority, which we don't have now. So we're saying that at least perhaps there should be a tribunal in the cases where the community is dissatisfied by the decisions of the board. For them not to necessarily having to opt for the court process, we're saying that at least they must reach out to this tribunal as part of the dispute mechanism structure to register their dissatisfaction, so that this structure must look into those submissions and where necessary to advise the board to reconsider the redetermination. So we're just providing for that dispute mechanism process and to avoid litigations and other exceptional cases that might also derail or delay the electoral processes given the court challenges that are associated with the work of the board. So other matters can be settled there before the community can resort to court process because sometimes litigations are costly as well and time consuming. So this slide just shows the summary in terms of how the word delimitation is process is just detailing that process, which I may not need to waste time on. So 47 deals with municipal capacity assessment. Here we're just making it mandatory because it's there in the Structures Act that the board must conduct municipal capacity to ascertain the capacity of a municipality to deliver services. So we're saying now that because it does not have a timelines there, so we're saying at least once in a cycle of a term of municipal councils, they must conduct at least one municipal capacity assessment so that we're able to know this can also assist sector departments that are providing services within a functional service delivery area in the municipality. This may be water or sanitation, whatever case may be, so that before we resort into determination of a municipal boundary, at least we must ascertain where is the municipality lacking. If it's water issue, then the Department of Water and Sanitation can be able to support that municipalities in those instances, depending on the functional area of service delivery, so that the demarcation is not the last resort. Then 28 deals with regulations and guidelines. Here the minister is just being empowered to issue regulations and guidelines to facilitate the implementation of the Act. And in the National Assembly, proposed that the minister, while is empowered to promulgate those regulations, at least there should be an oversight from the side of Parliament. So those must be submitted to Parliament at least 30 days before promulgation for Parliament to also make inputs into those regulations before they become law, and including making those necessary inputs where necessary. 49 deals with offenses and penalties. Here we're saying that just like the IEC, if anyone tries to influence the board or gerrymandering, as I've indicated, for political reasons or whatever reasons may be, or such person may be found guilty or liable of fine or imprisonment, you would know that that also applies with the IEC if someone interjects with the work of the IEC or tries to influence the IEC or whatever case may be, are also subjected to the similar process. So given the nature of the work of the board, we are also providing for that. Then 50 deals with amendment of laws. That is why I indicated that there's various sections that are administered by the board, the provisions that are administered by the board, but now lies within the Structures Act. So we're saying that to ensure that there's uniform interpretation as well as uniform implementation of the Act, all those provisions is an opportunity now that they are migrated in the single piece of legislation for ease of reference as well. 51 deals with the transitional arrangement measures. Those are the transitional arrangement measures that may be dealt with, I think, through the advice from the Parliamentary Legal Services as the bill is processed, and when the President also operationalized the Act. You will know that that has happened with the National Health Insurance, where in some of it's implemented in part. So the way those transitional arrangement measures. So if we're saying we're changing the term of the board, it may not be immediate because now it's 7 years. There are people in place, there are board members in place. So it trumps between the term of local government. So we might need to have come with a transitional measure to say whether we pay for the remaining period or they complete or go beyond that and align to the term, whatever case may be. So that's what I'm trying to say, that some of the provisions might need those transitional arrangement measures, which may be done through the parliamentary advisory legal officers. Then 52 is just renaming of the bill to Independent Municipal Demarcation Act for the reasons I've indicated earlier. So this slide deals with the features of the bill, is what I've dealt with, it just summarizes what I've dealt with. But as it relates to municipal capacity assessment, we're just saying that while the board conduct municipal capacity assessment, at least must consider this, the performance of these 4 big functions, which are the provision of potable water and bulk supply of electricity and domestic water and sewage disposal systems and municipal health services. These are not limited to this. The minister can also issue the indicators in terms of what are the other areas that the board can look at to ascertain as part of the indicators the capacity of municipality to perform the services. And the capacity assessment is also conducted to ensure that those forms part of the reason why the board considers to escalate some of the municipalities from the status of a metro, from the local to metro, whatever case may be. So these are the proposals that were made by the Portfolio Committee in the National Assembly. They said in the composition, so that it becomes clear, as I've indicated, the composition part of the members of the board, is that is sometimes construed to mean it's individuals from different provinces to form part of the board. So they just indicated that instead we need to say broadly reflect the composition so that it's very clear. And they also inserted in the qualification to say we need to indicate that it's a relevant qualifications, and also the criteria in those members that are appointed as part of the members of the committee. They've indicated that those names of those people that are appointed in the committees must also be published on the website so that there's also transparency, and the communities as well, communities will be able to know who are represented in that committees. And the qualifications that applies to the appointment of the members of the board to also apply to those of the members. And they removed integrated development from the objectives of determination of or redetermination of, and they became clear as well in clause 30 to say and procedures must be stipulated in section 17 of the mechanism in place for public participation. And also the period within which the Minister can finance and the Minister of COGTA can be informed. They've extended that period to 9 months because they felt that after the financial year for the board to inform the Minister of the boundary changes, maybe they felt that 6 months maybe might be slim, so they allowed for 9 months period before the commencement of the municipal boundary changes, because there are also transitional arrangement measures that must take place when a municipal boundary is redetermined, and including the appropriation of funds in terms of rationalization of most of the stuff between the two municipalities in case of the major redetermination. And of course, from the side of Parliament, they felt that they need to also look into those regulations before the minister promulgates any regulations that is incidental to this act. So that marks the end of the lengthy presentation, Chairperson. Thank you.
Thank you very much, Ndate Mati, for that presentation. I'm sure it has been very empowering for members. We've also circulated for the members of the Portfolio Committee the presentation. So we are now going to move. The discussions will be later, members and stakeholders. We're going to move now to receive a presentation on the legal opinion on the bill. If you could also be guided, maybe just as an announcement on the inputs from the Portfolio Committee of the Legislature yesterday, how will those be embedded as well? Thank you. Please take us through the presentation. Kima. Right. I've just been informed that because the committee is, so we won't go through that at this stage. So we're going to move on. Stakeholders. There is no representative from SAGA, I'm told. So we're going to now move on to the metros, local and district, then we'll move to the political parties. Can we have a presentation? 10 minutes, colleagues, from Tate HOD, Tate Solofelo Kopeti, from the city of Ekurhuleni.
Good morning again, Honorable Chairperson and members and colleagues and other stakeholders. We'll just present some of the issues that we had picked up as the city of Ekurhuleni in relation to the proposed bill. However, Chair, let me take the opportunity firstly to say we welcome some of the amendments that have been made, and there are specific questions that we have queries on. I assume we'll get an opportunity during further discussions to engage with the colleagues on them. For now, I'll just focus on some of the things that we consider to be critical, starting firstly with the one limitation in relation to the use of the voters' register numbers to determine the wards. And we have identified that there are several challenges that arise when numbers of registered voters is the sole factor or the main factor being used for ward delimitation. So I'm not necessarily going to focus on the redetermination part for now. I'll come to that later on. The biggest challenge is the discrepancy in the voter turnout, discrepancies between registered voters and actual voter turnouts in some areas. Some wards have high registration but low participation, and underrepresentation of engaged voters. Engaged in voter engagement is not reflective of registered numbers. The population growth and migration, whilst this is taken care of in the redetermination aspect, but in the delimitation is not necessarily a factor that is to taken into account. Which leads to unequal ward sizes. and as well as inaccurate representation, where the registered voters do not reflect the total population numbers. And socio-economic disparities, again, lower voter turnout, registration in poorer communities results in a skewed representation, particularly if you take into account the formula used for PR voting processes, or voting PR seat calculation, that is. And of course, outdated demographic trends. And Chair, before I move to the alternatives, just to affirm where some of these limitations have been picked up from by the city, is firstly that if we accept that the legacy of apartheid spatial planning has created a situation that is not consistent with the special principles outlined by Spluma, which I will not go through all of them. I'm sure most of us are aware of them. But specifically, if we want to deal with the issues around spatial justice, we do believe that we need to have a rethinking of an alternative ward delimitation process, which I'll go through now. But one of the things that, and I think this may be an important discussion point even for the portfolio committee at COGTA and even national to think about, is the disadvantages and advantages of focusing on registered voters and eligible voters. Because if we are to deal with those issues as highlighted in Spluma, and if indeed the demarcation board is to ensure that there is a high participation in the democratic project, the voting and so forth, it's something we must think about. Because once you limit to registered voters and all these other things that I read earlier on, they're a reflection of that focus. And because if people don't come out, we are not thinking of them in terms of their spatial development. Going into the alternative or delimitation processes that we had thought of. Firstly is the incorporation of the entire population data. As I've just said, the benefits of using eligible voters vis-a-vis registered voters when we determine the boards, when we determine the boundaries, and also a more insight on what the census tells us. And of course, this goes into a question or a proposal to our colleagues that whilst we are saying the determination and redetermination must be every 10 years, we are not specific about the delimitation, whether it must be 5 years or it will be 10 years as well. So obviously our view would be that if we are doing a more focused and nuanced integration of the census insight, we ought to look possibly at 10 years and not 5 years. And then socio-economic analysis, a proper understanding in the context of voter registration and disparities within wards. As I indicated earlier on, this will also be informed by the elements of the spatial principles outlined in Spluma. You'd know that in many metropolitan municipalities, for instances, and to a certain extent, even in the local municipalities, there's a lot of spatial injustice in the sense that some of the wards or areas were built around buffers, whether it is industrial areas or whether it's mine tilings now, historically they've been set up around that, and that further creates more disparities for the wards, particularly when you want to integrate development in the communities. Of course, there's also an element of public consultation, which requires regular engagements to ensure transparency and stakeholders, and we think some of these things, in particular this one, has been covered to a certain extent based on the last presentation, as well as driving the democratic project in terms of boosting voter registration efforts with a focus on underrepresented areas to ensure equitable ward representation. Again, the issue of how the PR seats are calculated based on focusing only on registered population and the representation thereof of the different organizations that contest elections outside of the ward representation. And then just a few more points in terms of urban and peripheral consideration, to consider the growth in suburbs and informal settlements, which obviously are now populating most of these urban buffer zones that were created as an element of apartheid spatial planning, because that is where you find most of your informal settlements, and then as well as delimiting wards to reflect in a more nuanced way the socio-economic challenges of your historic township zones, and then considering other geographical factors, including agricultural holdings, environmental sensitive areas, mining areas, as well as dolomitic conditions. The issue of boundary management, I think it was spoken in detail when we were speaking about the delimitation, the redetermination process, so I think that one is covered. And the last two is the impact on service delivery, particularly to avoid excessively populated wards, which then lead to service delivery backlogs. And this is quite an interesting dynamic, because some wards you may find that the ward has reached a maximum in metros is 17,000, for instance, has reached a maximum of 19,000 and is determined as a major ward, but another ward, only fewer people have registered to vote, but because of the density of the population, issues of service delivery tend to suffer. So that's what we mean in terms of service delivery impact, and as well as alignment of wards with other planning instruments, in particular considering the special development frameworks of municipalities, as well as SPLUMA, as well as the NDP. And I think this goes into the whole principle of doing the municipal capacity assessment. And we think that's where some of these elements, when the assessment is done, must be looked into, not just issues related to bulk infrastructure and other service provisions as provided by the Constitution. Chairperson, I think from our part, we'll stop there. The one or two points that I've left out, we'll engage on with our colleagues during discussions. Thank you very much. If my colleagues want to add through you, Chairperson, I would highly appreciate it.
Thank you very much. Would you like to add? Yes. Yes, please. I don't know.
It's recorded.
It has to be recorded. I just don't know where's the mic, the roving one.
Thank you very much. Thank you, Chairperson, colleagues. So we picked up a few issues on procedure-wise. My colleagues have stressed that in terms of the legislation, there will be amendments. But I must note that, colleagues, that the Municipal Demarcations Act is repealed in its entirety. And the only issues I could find here that were in the new act that's going to come into operation is that you're establishing an authority and then you're providing for the appeals process. Because for the remainder of the clauses or the sections, it refers to the board. And then if you to take it, so that is where in the preamble and in the introduction, that's where it's contained. Now, if you're coming to if the act is repealed in its entirety, so if you look at part 3, let's look at public participation. I want us to look carefully into public participation and public consultation. I don't think they can be colloquially used because they have different criteria, and public participation may link more to meaningful communication rather than consultation would be in consultation or after consultation. And again, there could be vagueness that could arise. The most important aspect in this act or bill at the moment is that there must be the involvement of public at all stages and at all levels. The other issue is then the creation of the board. So after we establish, in terms of Section 3, establishment of the authority, we need to look at then the status of the authority, but it seems to be, the status seems to be linked to Schedule 1 of public Finance Management Act, why not Chapter 9 of the, it seems to be a Chapter 9 institution that's being created. So why are we referring to Public Finance Management Act in terms of the Chapter 9 of the Constitution? I'm sure we can consider that further. Then functions of authority, we've got the functions listed there. And then it comes to the powers of the authority, but in part 2, the board. So we're saying composition of the board. Now, do we not have to re-establish the board in this legislation, seeing that the old legislation has been repealed? Because where does the board come in now? From where are you bringing it? So do we not have to say the board is established and then the composition of the board thereafter? These are some of the things I think we should consider, Chair. And I think the appeals authority is welcome to cut down the challenges in the courts. But of course, to what extent we have to look at then in motion proceedings, if there's urgent motions. Would it still have to be, if you're going to have regulations, I suppose, that will list how the appeals process will take place, but let's look at the urgent motions, how we would deal with that.
Just mind your time.
Thank you. No, I think I'll leave it there, Chair. I've got colleagues from province here. We'll engage with them further if there's. Thank you very much.
Thank you very much. Thanks for that presentation. Can we move then? I'm told the next presentation will be from Mitval. Yeah. Mechabalala. Can we have the mic, please, quickly, that side?
Good morning once again, and thank you very much, Chair. I think that from our perspective, what we had covered, and also looking at the geographical context, what we had looked at, well, in terms of comments, is the criteria for determination or redetermination of municipal boundaries under Section 24, delimitation of wards, Section 35, public participation for determination or redetermination of municipal boundary, Chapter 3, under Part 3 and Part 4. So in terms of that, the municipal determination or redetermination is guided by the Municipal Demarcation Act, driven by the following factors: to enable municipalities to fulfill our obligations, democratic governance, service delivery, spatial and development planning, patterns of human settlement, employment, commuting and use of amenities, the ability to provide services, potentially altering a jurisdiction and impacting vote numbers. So our comments are pretty short, Chair. In terms of Part 1, when we look at, from a GSI perspective, the criteria under Section 24 provided is sound, and as one of the main concerns with the boundary determination is the potential of dividing communities or cutting off functional areas, which the bill does address sufficiently. Part 2, as mandated by the Demarcation Municipal Act, public participation is crucial for the determination or redetermination of municipal boundary. So by involving the community, the process is seen to be transparent and not driven by administrative or political considerations. As such, Part 3 and Part 4 under Chapter 3 addresses the process of public consultations adequately. But what we would like to put under inputs for public consultations, in the initial stages, post consultations with ward councillors, ward committee members, and CDWs. The reason why I'm mentioning this now is that we are currently undergoing the process now of public consultations, which was actually done on Monday. So what we would like to put forward is that in collaboration with municipalities, a knowledge session on the MDB process can be initiated, targeting communities. However, I mean, in this case, this would be beneficial beneficial because of the process provides an opportunity for communities to have a sound knowledge of such determinations or redeterminations to make an informed decision. Because of what we have picked up is that communities participate when they understand the process better and when they have more knowledge on the process. And then they can make an informed decision on whether to participate or not. So, and then also to empower communities by giving them a voice in decisions that directly affect their lives. This can foster a sense of ownership and responsibility for their communities. So in conclusion, with the benefits that are in existence, it is advised to address the initial process as there are challenges such as lack of knowledge pertaining to the demarcation process to ensure effective and meaningful participation. I think I think that I've covered all from our side. Thank you, Chair.
Thank you so much, Mayor Chabalala, for the input. And I'm sure that it has been submitted. Can we then move to the City of Tshwane, that Epile?
Chairperson, thank you very much, members of the Portfolio Committee. I stand in for our City Manager, Mr. Johan Mettler. As indicated earlier, he's taken ill. There are 5 specific areas that our commentary covers. The first one, well, we recognize the fact that the current bill is an improvement on the previous act, which is welcomed. But insofar as the independence of the authority and the appointment of members of that authority, we raised the issue around it is difficult, and maybe through our own experience in the establishment of the City of Tshwane, that board members are selected by the President. It would be difficult to envisage how political considerations would not play a major role in these appointments. So in order to strengthen the stated independence of the authority, we strongly believe that the nominations of people to serve on the board should be open, transparent to its conclusion. Part of our commentary deals with Section 11, and the major part of that, our commentary and concern, centers around the purely subjective nature that is given to either the President or the Minister to dismiss a member of the board. If you look at Section 11.8AV, or 5, it is open-ended and very subjective. And we are of the opinion that that must be jettisoned. Jettison is quite a rather strong word, but it must be removed because there are other clauses that will take care of members' delinquency, so to speak, in dealing with that. So there are lots of other objective criteria. Instead of having a subjective clause where it is of the opinion of the Minister or the President that such a board member, to put it, does not meet the confidence. And that can be legally, and we don't want the act to be, or the process of this, the demarcation process, to go through a whole litany of legal processes. So rather, let's prevent it from the start. Our next point is centers around, and I indicated this, the bill largely mirrors the Demarcation Act, safe to say for the inclusion of the independent authority, which is most welcome, which will deal with a number of problems that we in the city had to overcome over a period of time, be it cross-boundary municipalities, etc. And I'll touch on some of those things in my next point. Coming to the issue of capacity assessment, I think more than any other municipality in the Gauteng context, the city of Tshwane has been impacted both negatively and positively, but more negatively, on the capacity assessment problem. And I'll explain why I come to that. In 2000, when the final demarcation and the final elections for local authorities took place, there was a demarcation that brought in many areas that once belonged to the Northwest Province. Mabopane, Ga-Rankuwa, Winterveld, etc. That was most welcome, in a sense that that communities that reside there were part of the labor force or the workforce of the city of Tshwane, and then for them to benefit from the tax base of the new city was important. And for the new city to then deliver the required services. The unintended consequences of that is that many facilities that once belonged in that area, like your industrial zones of Babalegi and Ga-Rankuwa, still remain, after 25 years, a contested terrain. All those industrial zones, all industrial areas, are almost near to collapse because they do not fall within the legal jurisdiction of the city of Tshwane. They fall within the Northwest Development Corporation, which has another authority that it reports to. But the impact, and that's why when we do assessments, we need to understand the implications and what needs to happen. So for 25 years, the city has been on an ongoing basis right up to what was then called the Presidential Coordinating Council at the highest level to address this matter, still unresolved. The second problem was the 2011 redemarcation. We don't believe that there was a proper capacity assessment done, where the whole of the Metsweding district municipalities and its two locals were amalgamated with the city of Tshwane. That brought with it similar problems, because there are a number of cross-boundary matters that are still unresolved, and one of the major industrial zones and railway transportation lines still belong to the Mpumalanga provincial government and the agency that deals with the industrial areas in there. What we've resolved just recently was the transfer of housing properties to the city of Tshwane, so that those houses could then be transferred to owners. But the rest of the land and the rest of the infrastructure in those industrial areas still belong to Mpumalanga Economic Growth Agency. And we don't have any control on fixing. So what, as a result, what had happened is that that industrial zone, which was once upon a time employed something to the tune of 6,000 people and growing, now has been reduced to almost 1,000 odd, with factories relocating elsewhere in the province. Having said that, The 2011 demarcation impacted upon how we categorize and define a Category A municipality. If you look at the Structures Act, you'll find that the current city of Tshwane's geographical boundaries do not mirror that of a metropolitan city. It's highly urbanized, it's highly agriculture, and it's highly peri-urban. With the amalgamation of the erstwhile Metsweding District Council, the city lost out on its fair share of the national revenue because the FFC formula at that point in time, let me use the word, was biased towards peri-urban and rural districts. Now that you incorporate it into a metro, you are considered differently, whereas the status quo remains the same. So when we talk about capacity of municipalities, the capacity should not just go in terms of political expediency, or it should be a thorough examination of the failures of that particular municipality or the potential if we change how it is structured. In the context, and this is my own view, it is not the city's view, but I thought it necessary to make the point that maybe we should do away with district municipalities and have local municipalities. That's my own view. It's, and please, I know it's on record, but we need to seriously look at those kind of issues.
Yes, you wrap up.
In conclusion, thank you, Chair. We support the bill and we welcome the new provisions. Thank you very much.
Thank you, Ndate Pile. We don't have a representative from Citibank. And I think when we were discussing that we must write to those municipalities whose head of departments are not here, we also must mention that Johannesburg, Citibank, and municipalities from the Western are not here. So, is Johannesburg here? Oh, geez, I was wondering, such a big metro. Okay, no, thank you so much. So, yeah, but those that are not here, we must also write to them. So, can we move then to Johannesburg? Are you going to present?
Chair, we had prepared the presentation, but after some discussions and really looking at the bill, our issues are going to be covered. In section 28, we had issues related to the redetermination of the municipal boundary, and also on the delimitation of wards, which is covered in part 4. So with the establishment of the committees and also the appeals authority, our issues that we had previously are going to be covered in those areas. So we withdraw our presentation on the areas that we had raised. Thank you, Chair.
Thank you very much. I just want to reconfirm, Lesedi, you're not presenting? Are you presenting? Okay, Lesedi is not presenting. Mfuleni? Mfuleni is not presenting. I hope I'm not leaving any other municipalities. So those are the municipalities. They've all presented. So I'm now going to move then, honorable members and stakeholders, to the political parties. Earlier on, I had mentioned that we will call out the political parties as they had confirmed in that order. The first presentation, 10 minutes for all, Action SA.
No, thank you very much, Chair. Try and take less than 10 minutes. Chair's Action SA, we welcome the opportunity to participate in this important roundtable. And we appreciate the consultative approach adopted by the Portfolio Committee. We recognize the necessity of upholding South Africa's municipal demarcation framework. However, Chair, any legislative reform in this area must promote democratic accountability. It must enhance service delivery and ensure the financial viability of municipalities, especially in Gauteng, where spatial inequality remain a persistent challenge. Action SA supports the intention of the Independent Municipal Demarcation Authority Bill to modernize the Municipal Demarcation Board, clarify institutional roles, and introduce an appeals process. However, Chair, we want to raise three fundamental concerns. Number one, the timing and the frequency of major boundary reconfiguration is a concern for us. The adequacy of public participation provision is also something that we are concerned about, and I think some of the speakers have touched on it. The lack of clear transition support for merged municipalities, particularly financial and capacity building frameworks, is also one of our concerns. If you look back to the Rand West merger that happened, we don't think that they were really supported with, in regards to their financial capacity and also the governance capacity. Our recommendation, and maybe on some of these issues, we are advocating for democratic participation and procedural justice. The bill introduced positive reforms through section 29 to 31 on public consultation and objections. However, in practice, as noted in the previous boundary changes that I've mentioned, the one of Rand West in 2016, even public participation often remains a superficial and symbolic exercise. As Action SA, we want to recommend that notice periods be extended beyond the minimum of 30 days, that localized participatory mechanisms, ward-level meetings, translated materials, radio broadcast, they must be mandatory, not discretionary. We want to recommend that community input be formally recorded and responded to in the final demarcation report. We commend the bill's effort to establish a more independent and professional demarcation body. Prohibiting political office bearers from serving on the board, clause number 9, is very much welcomed. However, the appointment process still remains centralized through the minister and the presidency, creating a perception of potential political influence. As Action SA, in this regard, we propose that the final selection of board members must include multi-party parliamentary approval to safeguard independence. We propose that all board deliberations, especially those involving boundary changes, must be live-streamed or recorded for transparency. Chair, the bill enables large-scale boundary changes every 10 years. I think that's clause 26, but it fails to institutionalize the mechanisms for post-merger support. Evidence from the socio-economic analysis that we looked at yesterday, Chair, that was compiled by our researcher, shows that many merged municipalities, Rand West municipality as an example, struggle with financial instability, tariff harmonization issues, and workforce misalignment. There's no transitional grant or due diligence processes prior to these measures. To that effect, as Action SA, we recommend that a mandatory 3-year transition support package be included in the bill, that the National Treasury certify affordability and budget availability before any proposed amalgamation is approved, that Section 47, municipal capacity assessment, be expanded to include mandatory post-merger reviews. In terms of appeals mechanism, we are of the view that the establishment of the demarcation Appeals Authority, Chapter 3 and Part 5, is a commendable reform. However, it lacks clarity on the scope of relief it can offer. It lacks clarity on the binding nature of its rulings, whether it has investigative capacity or simply reviews paper-based objections. To this effect, Action SA recommends that the Appeals Authority be empowered to conduct public hearings and field investigations, that its rulings be binding unless overturned by the judicial review. Chair, in conclusion, as Action SA, we support the broad objectives of the bill, but really calls for the meaningful reform to, number one, deepen democracy legitimacy, number two, to ensure fair and well-supported boundary changes, and to shield demarcation processes from political manipulation. Chair, we urge the committee to use its oversight powers to ensure that the final act advances constitutional values of transparency, of responsiveness, and developmental local government. I thank you.
Thank you very much, Member Ngobeni, on behalf of Action SA. I'm moving to the IFP. Where's the mic? Okay.
Behind us.
Thank you, Chairperson, the acting Chairperson of the committee. Greetings to all members, honorable members that are here, and also the colleagues. My name is Madoda Yende from the IFP. Exactly what we are going to say, we do welcome the bill, but we have some questions also or concerns in part of it. I'll just start with clause 7. In clause 7, which is talking about the broadly reflect of the composition of South African society. In that issue, I think exactly it does not state very well how are they going to be elected, those members. I think when we are talking about the composition of South African society broadly, 7 members to 10 members, it has to give us a clarity how are they going to be elected, because we know before, as it was talking about regionally, it was clear that in those regions or provinces, they will be elected according to that one. But I want to get clarity exactly when we say that just the composition of all South African society, how are they going to do it? And also, in clause 29, I'll just put it in 29 and 30, which is talking about public consultation for determination. In that clause, we'll also request as IFP that this has also to be really done, because most of the times they just write dates and say there is public consultation, whereas it is not done clearly. So when we are talking about that one, the public participation and public consultation, it has to be monitored and also confirmed even in municipalities or other stakeholders that it has been done thoroughly. As we always know that most of the bills or anything that has the community has to participate in, they say there was public consultation or public participation, whereas it has not been done. So it is, as it is saying that in 29, in clause 29, the authority to publish notice in local newspapers informing stakeholders of public meetings, and for the authority and to communicate the same message through the means. I think also it has to mention in that clause that there must be a thoroughly monitoring, especially for public participation, because yes, consultation in newspapers can be done, but you will find out that the community did not come or get the chance to participate there. And also, I'll go to clause 35. In clause 35, I think in that clause, which mentions about the criteria for the ward delimitation of the wards. In that one, I don't think that the proposed 30%, I have to second it, because it will mean that in each of the wards, it will make a huge difference between or among the wards. Especially, let me make an example in the city. That 15% in the city of Johannesburg, let me make just an example. That 15%, the minimum norm and the maximum norm, I think it was quite correct, because there was not more difference between or among the wards. But once we say it now to 30%, it will exactly make two different. In other words, you will find that maybe, as I'm making an example, maybe it's 12,000. The other wards, you find that is 24,000, just because of that 30% deviation. I think that one also has to be corrected. I think, as I've said, that we are supporting the bill, but there are certain issues. Let us look thoroughly in those ones, especially as I've said that in that criteria for the delimitation. Thank you very much.
Thank you very much, Thank you for that input. So we are going to move on to the ACDP, the chair next to me.
Thank you, Honorable Chair. Let me again acknowledge the honorable members of the Portfolio Committee. It is good to be with you today at this roundtable. Let me also acknowledge the support staff for the Portfolio Committee and also the different municipalities that are present here today. I also want to acknowledge my two colleagues from the ACDP that is here, Mandy Thinis. She's the Provincial Secretary General of the ACDP in the Gauteng Province and also Executive Secretary in my caucus office. And next to her on that side is Mpho Mogatla, who's the finance in my caucus. You must always work with the finance person. It's a good thing. Like you. Today, I'm now at this point, I'm going to wear my cap as the provincial leader for the ACDP in Gauteng. So I won't be speaking on behalf of the legislature as the chair of chairs, so the members must just take note of that. So this submission is made in respect by the ACDP of the Independent Municipal Demarcation Authority Bill, for which comments of interested and effective stakeholders have been solicited. Right at the offset, it is important to place on record that the changes proposed in the bill for enhancements and improvements are always welcome, as long as they serve the interests of the communities they represent. This is very important to us. It is welcomed by us as long as it serves the best interests, as I said, of the communities fairly and openly. By way of background, the South African Municipal Demarcation Act of 1998 establishes the Municipal Demarcation Board, an independent authority responsible for determining the redetermining municipal boundaries. The Act aims to ensure efficient local governance by defining municipal areas based on factors such as population, economic viability, and service delivery capacity. However, the demarcation process has faced criticism. Some argue that the political influence, I underline that, affects boundary decisions, leading to dissatisfaction among affected communities. Others highlight that frequent boundary changes create an instability in municipalities and municipal governance, making long-term planning and service delivery more challenging. Additionally, some municipalities struggle financially due to demarcation decisions that do not align with the economic base. Overall, what the Act provides a framework for municipal boundary management. Its implementation has raised concerns about governance, financial sustainability, and public participation, as mentioned by other colleagues. The bill now proposes review to the Act. It must be noted that the bill does not constitute a significant and material departure from the current Act. It is largely aligned to the current Demarcation Act, with some amendments for enhancement. One of the major amendments to the current Act is the inclusion of communities affected by any proposed demarcation to participate meaningfully in the said processes. The current Act does not provide for public participation to the extent that the bill would now require. This is supported and indeed welcomed because municipalities are in a constant state of flux due to migration and or increased urbanization. Many smaller municipalities, particularly those without a sustainable revenue base, have become more financially unviable. With that in mind, it is our considered view as the ACDP that this amendment be supported in principle with the following key considerations. 1, the Amendment Act should consider socio-economic and developmental needs of municipalities, as well as how to address cases where provincial boundaries affect municipal boundaries. 2, the formula to determine councillors, whilst distinguishing between categories of municipalities and their overall socio-economic dynamic results in situations where contagious municipalities may have very different arrangements in terms of the number of councillors relative to its electorate. In such cases, if municipalities are merged, the smaller municipalities may become underrepresented in the new municipality. 3, potential mergers should carefully consider the impact of representation in relation to voters and always ensure fair representation, equity, and parity. Number 4, the Demarcation Board should clearly outline the criteria of demarcation to the communities involved, as this will create a better understanding and thus avoid unnecessary protests and resistance. And ultimately 5, the new demarcation should withstand changes in leadership post-elections as well as ever-changing mandates. Service delivery should always and at all times be prioritized. And 6, change is never easy, and dedicated teams should be assigned to work with the merged municipalities to assist in managing the change process. 7, financial viability and capacity to sustain services should be among the key considerations forming parts of a detailed due diligence study preceding any decisions to merge. One of the colleagues also mentioned that. And 8, post-merging, provisions must be made for at least a 3-year transition process with funding for change management and other related implications such as billings, CRM processes, human capacity, and the like. Drawing to a close, Honorable Chair, all in all, to ensure the Municipal Demarcation Act truly serves the people, communities must be actively involved in boundary decisions to prevent dissatisfaction and protest. Further, boundaries should be drawn to enhance access to essential services, but at the same time, the merged municipalities must be financially sustainable, avoiding demarcation changes that weaken their economic base. Very importantly, Chair, Demarcation decisions should be free from political influence to maintain fairness and transparency. With that in mind, one should also caution against frequent reactionary boundary changes as these disrupt governance and planning. And to mention here, I have noticed over the years where informal settlements find itself being erected primarily so that the balance of votes could be somehow brought into the fray and into the picture, not having done a thorough due diligence in terms of that community. The second thing, Honorable Chair, is the socio-economic challenges that you have disparity. In one ward, you can have the haves and the have-nots, and you find that it is imbalance where the budget most possibly favors the haves than the have-nots. Overall, municipal demarcation should support national frameworks like the National Spatial Development Framework and Integrated Urban Development Framework to reduce spatial inequality. Balancing these factors, Chair, can help ensure that municipal boundaries support effective governance and community well-being and facilities effective service delivery. This is ultimately our primary concern, that this bill must, in its totality, be majority leaning towards, or usually leaning towards service delivery for our people. I thank you, Honorable Chair.
Thank you very much. I don't know if I should call you Bishop Adams or Honorable, but yeah, the provincial representative from ACDP. Thank you so much for that. So we're going to move now to the MKP. Honorable Nyati was here, he had to leave. There was a crisis he was attending to, but I'm sure there is another member who's speaking on his, on the behalf of MKP, or not?
Yes.
Okay,
Yeah.
thank you.
Good morning, Chairperson, and good morning to the members of your portfolio committee, officials from different municipalities and the political parties present here. The MK view on this matter is going to be slightly
Sorry, if you
different.
could just also introduce yourself.
Oh, sorry. My name is, so we welcome the opportunity to participate in this very important discussion. We have serious reservations around the rationale behind the proposed existence of this bill as MK. Not so much around its mechanics. Precisely because our view is that all the challenges that so many of the presenters have spoken about this morning are speaking to state capacity. If the idea is that if the state is unable to do something, we must establish something outside government, which is going to be independent to deal with problems which I believe the state and MK believes that the state should be dealing with. Ideologically, there's a big problem there. We note that we've had tremendous challenges with demarcation of municipalities since '94. But an idea that this is going to be an independent institution which is not going to be susceptible to political influence is a mythology. South Africa is a country that has just emerged from apartheid and colonialism. For us to subject a very important process to an independent, or the so-called independent, unelected individuals, to preside over geospatial determination, the territorial integrity of the state to be controlled and be determined by a board and a CEO instead of elected officials is a serious problem, which I think we must investigate. We feel that this erodes the capacity of the state. And the state represents the electorate. It is through the electorate that the state exists. A situation where our elected officials no longer have this capacity within their control is completely unacceptable from our part. This geospatial determination, as I'm saying, is an unmitigated competency of the state. For us, I think the rationale really, I would have hoped that there's a greater emphasis of why it should exist. I mean, we recognize the authority from 155 of the Constitution. But of course, even that needs to be looked into. South Africa is highly contested territorially. There are enclaves of people where other races are not allowed. You know, there are groups of people that want to succeed. In KZN, there's a Ngonyama Trust, there's territorial disputes. And all of this, we are saying, must be determined by an independent group of unelected people. I think we need a debate quite intensely around that proposition. And I think that if the argument was to say there was nothing that could be done to enhance the existing statute, to enhance the existing capability of the state, then it will be something else. We have very, very, very serious reservations. And we do hope, I mean, even the intervention, we don't see a very clear intervention that a state could make in cases where some of these decisions are contested, other than that, the fact that the minister will be consulted. It's just a mere consultation, but most of these will be determined by the courts of laws. So this will be run through the courts, essentially. That's the account of what it suggests. And I think that we are doing a great deal of injustice to very logic of the electoral process, because elected officials are elected by our people. It's our people that have elected most of us who are here, those who are in government. And when you've taken that right, and you've vested that right in a group of individuals that are not elected, that are nominated by the president, what are you saying about that right, about the right of our people in a democratic dispensation? So there's a philosophical challenge which I think we need to deal with here. If we need to deal with problems in this country, we must learn to capacitate the state. The state has capacity to employ expertise if there are expertise required. The state must pass right laws to make sure that there are enforcement on areas where we think there are weaknesses. But to take a view that because we have these challenges, we must therefore look at bills of establishing independent institutions around the territorial integrity and its configuration in a country like South Africa is absolutely dangerous, to say the least. So I do want to say, let us reconsider. As MK, we want to state that unequivocally. Let us reconsider the implications of what is being discussed and proposed here. And we are repealing the entire statute that was governing this process. And are we saying that the grounds of justification are such that we could not have intervened to deal with the problems that some of the honorable members were talking about, that we've had in the demarcation in different, since '94, we've had many, many problems. And yes, it's susceptible to political influence. That's a reality. But I mean, who can say that this independent authority will not be susceptible to political influence? None. The president will appoint, I mean, the question of representativity itself is also going to be contested. So what you will have here is a very highly contested group of people that are going to determine the geography of this country. And I think, in our view, that is going to give us many, many, many challenges, and it will do a great disservice to those that are going to be voting We're going to local elections, not in less than 12 months, maybe, in this country. What are we saying to those that were expected to, to vote for us, when we can't even decide on such a crucial matter? We've relegated this authority to almost private hands. It's a challenge, and I hope that these views are taken into consideration. Even with the NDP, really the center of gravity of human and economic development lies with government. And I think philosophically, if there are issues with government, let us work and discuss how best do we capacitate the state. This can't always be the solution. That when there are issues, we jump and start setting out external institutions to deal with issues that the state is supposed to be dealing with. Yeah, I think that is the thrust of our submission, Chairperson. Thank you very much.
Thank you very much, Ntatengwele, on the presentation from the MK. And I'm hoping that, because I saw on emails that we've been receiving some of the presentations, formal presentations, if you could. So we are going to move now to the Democratic Alliance.
Yeah, thank you very much, Chair. My name is Nicole van Dijk. I am an MPL, but I was also a former PLC rep in the city of Joburg. I know that we gave comments yesterday, and I just want to say this from the outset, that we hope that those comments will be included with what we're going to be presenting today as well. I think it's very key to start, especially where the colleague from Ekurhuleni kicked in. You know, the Municipal Demarcation Board has admitted that it only looks at the number of voters rather than the number of residents. And having been a ward councillor, my ward was relatively small, I only had 27,000 residents, but we've got colleagues, especially in other metros, that are serving up to 60,000 residents, one representative. It is a gargantuan task for a job that is considered part-time, when it should actually be considered full-time. And there has to be a point where the demarcation board is going to look at the number of residents within a ward rather than the number of voters, especially when we see that largely in Gauteng, only 49% of the province is registered to vote. Having said that, municipal demarcation is so important to how a city functions. And the people who know those cities best are the elected councillors. It's the officials in the city, those in the municipal manager's office. It does not sit well with the president. So the president appointing this board does allow for political interference. It also doesn't allow for technical knowledge to be applied to the demarcations, especially when it does come to service delivery, when it comes to, I mean, if I can give an example, there are wards in the city of Johannesburg that are serviced by Ekurhuleni and their power and water utilities. Same thing, Mogale City, some of them are serviced by Johannesburg. So it's clear that even with the demarcation board operating at a municipal level, that we are not getting a full understanding of how this is operating. And I think if it had to go to a national level where the power lies with two people, the president and the minister, and them appointing these boards, boards where it doesn't actually specify what technical knowledge they need and how they're going to apply that knowledge. So we do tend to agree that if it only lies with the president, that these boards are going to be politically appointed and you're going to lose that technical expertise, and it does allow for political gerrymandering. It is a concern, and I think it needs to be taken seriously. We propose that the appointments of both the appeals and this independent board, that it gets done by a parliamentary sitting, a multi-party parliamentary caucus that would be able to look and actually apply their minds and have fairness applied rather than one person overseeing it. public participation is a big thing. Public participation in the city, well, basically in the country, is not very well managed. Too often we see that there's a small advert placed at the back of a newspaper that no residents are going to see. Then they don't participate. And that is, and what classifies is you've just put that advert in. If only 5 people show up, public participation has happened. We need to see, and you raised through you, sir, and via the chair, that you're going to be using local newspapers. We'd like to see something much broader. It needs to be not only in your local Caxtons, which are very vital to community participation, but community radio stations, national national television, SABC, all of these platforms need to be used to make people aware that this public participation is happening, and also with a brief disclaimer of what they are commenting on, because there are a lot of residents who don't even know that this MDB exists, and how it affects their lives. So, sorry. With it being politically appointed, we see this with boards across the cities, across state-owned entities, where boards contain family members, they contain friends, people who are aligned to the powers that be. So again, this is why we promote, that we push that it should be done through a multi-party sitting, where they will choose those elected representatives to the board and the appeals committee. There's no requirement for transparency as to how you're going to be appointing these boards. What will you be presenting to the public if it's once they're appointed? How are you going to present to the public as to how you chose these people? What were the qualifications that you were looking at? How much time was spent on the appointment of these boards? There's no limit on how many committees this board can then appoint, subcommittees, new people that can be coming on. There isn't a limit on that, and I think it also takes away power already from the board that's already been appointed. And this, again, allows for national government to override local authorities. I think we've got to make it very clear, this is local government. National bodies that don't understand how local government functions, what the boards look, what happens in municipalities, it's actually going to lead to a bit of a crisis situation, and I think it's going to leave a lot of South Africans very unhappy. In clause 23, the municipal capacity is judged in relation to the ministerial and MEC powers. It's a very unclear rationale. It's ambiguous, and it weakens the objectivity of fairness and decisions. The appeals mechanism, it's also slightly flawed, clause 38. It allows for executive interference in the appeals process. Again, it's not transparent. It doesn't allow for for residents to see what is happening. And again, it's not presented at a committee portfolio sitting. So if that's not happening, where will the oversight be in the National Assembly as well as in the local governments? We also look that public participation extends from 6 months to 9 months. As I've highlighted, public participation is probably the most vital point within what we are discussing here today. And it can't just be a small advert. There needs to be ongoing public participation. It should be regular. In conclusion, Chair, we do not support this bill. There are far too many irregularities. It's giving far too much power of local municipalities over to the national government, where it should not be. The appointment of the bodies is lacking complete transparency. There are no safeguards to protect against political gerrymandering and manipulation. And I think I'm going to leave it there. I think I've covered everything I'd like to talk about. Thank you.
Thank you very much, Ms. van Dijk, for that presentation. So we're moving to the next presenter. Is it Ndate Albus? Yeah. So I must also not refer to you as Honorable Albus because you are having another cap, isn't it, for Freedom Front Plus?
Yes.
Okay, thank you.
Thank you, Madam Chair. We don't have a presentation that will be shown to you, so we're just going to talk to some of the matters that's of importance. First of all, we have a question regarding the process of the bill within the Cabinet and Parliament. We have not heard whether the department has created a socio-economic impact study on this bill. This bill has huge consequences for South Africa as a democracy, as some of the previous speakers have also noted. And we need to know what the impact, the possible impact of this bill, when enacted, can be on South Africa as a whole, and especially on the democratic processes in this country, especially with regards to local municipalities and local governance. So the question is whether there is a SEAS, what they call it a SEAS, Social Economic Impact Assessment, and it's compulsory to create one. The Cabinet has created a process in 2007 whereby all departments, when they create policy, when they create bills or acts, Parliament, and when they create regulations, it must be accompanied by a SEAS. And the SEAS, the size and the scope of the SEAS is informed by the importance of the policy or bill or regulations. And I would argue that this bill is of huge importance and is central to South Africa's constitution, and it's set up as a democracy in the end of the day. So we need to take note whether a SEAS was created or not, and if there is one, it must be submitted to all parties to read and to respond to that as well as part of the process. That must also happen in Parliament, not only in the legislatures of all 9 provinces, but also Parliament itself. Then, on the bill itself, the appointment of a selection panel, a removal of members on a selection panel, and the appointment of members to the board, it concentrates too much power in the hands of the executive by way of the president. We do not think that the president must be the sole person who appoints these people, because they are supposed to be independent, and I think the independence is undermined by the fact that the president himself, by virtue of the way the democracy works, is the leader of a political party, more often than not. So it would be quite progressive, I would say, and it would be in line with many other appointments, like appointments on ICASA's board and so forth, to submit all decisions made by the president and also all decisions made by the minister, where he's empowered to do so, to Parliament for scrutiny and final appointment. So the president can recommend, the minister can recommend, but Parliament appoints. Because we are a democracy, that provides a basis of transparent and democratic principles that is being applied. We have taken note that the ministerial guidelines are to be submitted to Parliament for approval, and we want those powers, or not powers, but the oversight function of Parliament to be increased and also applied with regard to the appointments made by the President and the Minister himself. Regarding the board members, we would like to see more expansive clauses that speaks to their fiduciary duties. If you look at the Companies Act, you will see there are many obligations that a director of a company must comply with to ensure that the director acts in accordance with the law and also acts in accordance with the interests of the company. Likewise, the board members must act in the interest of South Africans, and especially members of South Africans who have the right to vote in these elections. So the fiduciary duties must be expanded and must be created on a basis akin to that of the Companies Act and the Companies Law in general, the common law inclusive. Then, second last point, the demarcation criteria. Whenever the board uses criteria to demarcate areas into wards, they must disclose in public what those criteria are. How did they go about to decide that a ward must be divided in two, or whatever decision they have made. The public must have the right, including us as political party representatives, to scrutinize these criteria to make sure that it is rational. And thereby, it also protects the board, because if there is open, transparent process, then their decisions will probably be changed in a process of feedback on the criteria, and it will keep people from litigating and going to court when a decision has already been made. And then lastly, public representation or participation is very important. We've seen how many projects have failed because of the lack of public participation. The Constitutional Court have ruled on the nature of public participation, and we need to make sure that the bill is aligned to that. And we must make sure that public participation is really easy to do for the public at large. We've seen with the e-toll system that the lack of public participation has created a huge uprising against that system, with years of fighting between government and the public in that regard. And we most certainly don't want to see the same thing happening when it comes to ward delimitation that people might see as biased. So they need to have, they need to be enabled with modern technology and otherwise to make sure that that they know there's an opportunity to be heard, they know what the matter in front of them is, and that they then represent their communities and make representations of both their communities and themselves regarding ward delimitations. And that's all. Thank you very much, Chair. I appreciate the opportunity to make a contribution. Thank you.
Let me thank all the stakeholders for the presentation. Thank you, Advocate Alberts. I needed to address you with that title. You studied for it. Yes, so we want to really thank you for that. So I'm going to open up for discussion now, but starting with the members of the Portfolio Committee of COGTA. Trying to check the members outside again. All right. Maybe can I request that we have just 5 minutes of a leg stretch, please? Because I also need some comfort break. Thanks. Honorable members and stakeholders, we are reconvening. Thank you very much. We are on the discussions by all portfolio committee members. Know that we had a meeting yesterday on the same matter. You might also still want to reiterate some of the points that you raised yesterday. And then we'll also give over to stakeholders to also comment. So I'm going to go around the table and see if there's any input from Honorable Mokhobe, Honorable Raslingwani. Okay, and I'll also make an input in that order.
Thank you, Chair. I think yesterday we lamented, I think, to just tighten up on public participation and recognize it as an important part of ensuring that this bill becomes successful and we deal with what you call conflict resolution. Because of importance is that we need to be able to be thorough and put systems in place with this bill to ensure that we monitor the public participation process and, of course, whether it will cover all sectors of society. I think we also lamented on issues that speaks to using technology to also conduct public participation. But also, more or less, I'm happy that the bill will then have your appeals authority, which then will then deal with issues to resolve any conflict or any oversight that would have been undertaken. But my quick worry in this, in the presentations or in the inputs made, is that there seeks to be a suggestion that being politically active or being associated with a political party might be criminal. And of course, that's a dangerous way of trying to analyze and resolve problems or any wrongdoing. And I think that will also be infringing on the rights of ordinary citizens from being associated either with politics or any political party. And I think it will be important that we become fair enough that wrongdoing must be called out as such, it must be wrongdoing. But we must not make it look like it's criminal to be associated with politics or with a political party. And the independency of institutions, of course, would be respected. But it is important to put system in place for people to account if they are doing wrong things. And I think as we lament and deal with these particular matters, we need to recognize that elected people as well have got a mandate to serve and influence, of course, what the people would have elected them for. And of course, that particular right needs to be respected, and of course, we must not run a risk of making contributions that assumes that politicians would be corrupt if we don't make this particular process independent and all that. I think for me sitting here, there's an assumption already that they would attempt to do any illegal activity. And of course, I must start to question myself why I'm here or why am I a politician in this particular process. I'm just saying that it would be important also not to infringe the rights of individuals to be associated with politics and to be politically active. And then as in we deal with mechanisms of ensuring that nobody does any wrongdoing. Thanks, Chair.
Thank you very much, Member Mokhobe. Colleagues, considering that other members are not giving their inputs now, but we had committed yesterday that the inputs that were made by members will be included in the negotiation mandate, and they will be adopted by the portfolio committee. And also noting that some of the inputs that were also made, they do correlate and are aligned to some of the inputs that were made today, especially on the public participation. I want to add on what Member Mokhobe has just alluded to, and which is something that we also emphasized yesterday, that there has been court judgments or labor cases that we would have to refer to with regards to the demarcation board processes, so that we don't only work in isolation, and we're able to infuse those judgments, and the legal minds must sit together. So national, and I know that was it Ndate at the back, who also pointed out some of the legal aspects. I think it's important, even from the from COGTA here in the province and legislature, that the teams do sit and they sift through those inputs when it comes to the legal requirements. I think from my side, yes, I am really concerned about, in fact, let me refer to the case of SAMU when it comes to the office bearers, people who hold office bearer positions in municipalities who were meant to have resigned and not work for the municipality, and I think they won that case. So that judgment needs to be referred to. It's the same that I wanted to plead, that we must ensure that there is no interference in terms of the freedom of association of individuals, and in terms of their political rights. The section that we pointed out and I submitted yesterday, that we need to look at, so that we are not found to be unconstitutional in the way we are working. So we must also be aligned with the Constitution. So that's the request, I think, from my side. In as much as the intended amendment is really on ensuring that there's no political interference, that there's credibility, that we support. But what we would not want is that there must be an infringement on the Bill of Rights and the freedom of association of individuals. So I'll stop there, but we did receive the socioeconomic impact assessment, and I think the request is that it needs to be made available to other members, and we are going to compile that report and ensure that when it goes to the NCOP, all the inputs and views have been included. I want to open up to other stakeholders, stakeholders who would want to raise at this point. Oh, are we fine for the day? Is it because is it Friday today? No, it's not. Jeez, I'm hoping it's Friday. Oh, okay, it's Wednesday. All right. Yeah, there's a hand there, and I think. Okay, I wrote your name there. I know it starts with a K, but yeah, please go ahead.
No, thanks, Chair. I think the long weekends are over, so it's not Friday today. No, Chair. I think there were just 2 points that we wanted to engage on and ask our colleagues from COGTA specifically. Firstly, it's on the removal of on the objectives, on the removal of the objective on integration or integrated development. I didn't get it correctly. If we could just be taken into confidence on that. I don't know whether it was something that came from the portfolio committee or something that came in the bill, because as I spoke earlier on in relation to the spatial objectives in Spluma, once we take out that concept or that element of integrated development planning, it undermines the role of municipality in terms of ensuring that there is integrated development in the area using wall-to-wall development from human settlement, socio-economic development, and so forth. So just the rationale around that. And then I think this point was made earlier on, but I'll just repeat it because I had it down here. In relation to the economic impact on revenue of the municipalities when you do the determination, and I think the colleagues from Tshwane made a specific example. We've got our own examples in the city of Ekurhuleni, where time and again informal settlements in the boundary between Tembisa and Ivory Park, just as an example, where we get to receive all of these informal settlements. But however, this further down the line, Chairperson, it impacts us because it's not associated with any expansion from a DORA or from any other grants that are received in terms of us servicing those informal settlements. So I think the issue of that, the economic impact and revenue and that consultation is something that needs to be looked at. But in the main, the first question around clause 23, removing the integration thing.
No, thank you very much. Maybe before the department, whether province and national would want to respond. I think there was also a question of clarity from the IFP. I don't know if it was noted. If you can also respond to that.
I'm not sure, Chair, that I should be limited to those or to those that...
No, respond to all and whatever that you would want us to...
Okay, thanks, Chairperson. Maybe firstly, I would like to acknowledge the comments or representations or submissions that came out from the different parties and municipalities as well as the stakeholders. For me, I understand that we need to acknowledge that because it's part of this process that there need to be submissions which can also be submitted to NCOP for further deliberation, so we cannot shut down anything. But I thought maybe to clarify some of the intentions of the Act, of some of the provisions. The first one that I noted is the issue around the use of population versus registered voters. The rationale behind, maybe to clarify first that that does not reside in this bill. It resides in the Structures Act in terms of the determination of wards. But what I needed to indicate is that this has been, it's not the first time it's proposed. It came in the amendment to the Structures Act, the one that came into effect in 2021. So while it was deliberated, as much as I recall, it was shot down that we can use the population because for the reason that it's not easy to verify population other than the registered voter. And you will know that census comes after 10 years. So the word delimitation or the term of local government is 5-year term. So hence the use of the registered voter. So it's verifiable, it's auditable. You know, elections comes with contestation, whether in terms of the counting. So it's easier to verify a registered voter. And you would know that, not to mention that at one point the census was also questionable. You would know the recent issue around it being questionable. So in that instance, what are you? It will mean that you must nullify the election or those that would have been voted because the census became, and it can be played with or tampered with because it's a population, unlike a registered voter. Hence, it was shut down during the time so that we stick into registered voters as is auditable, verifiable as well. The issue around the use, whether the application for the major redetermination is 5-year or 10-year, or whether it applies to ward or major boundaries, that applies to major boundary determinations because ward needs to be changed in each and every election because the population growth and depopulation as well in that process must also be taken into account when the wards are determined. So the ward would have changed in the 10-year period. That is a huge period to consider a ward delimitation. So we limited that to major redetermination, those if more wards are affected. So that was the intention thereof. The use of consultation versus participation, I think the analogy that can be drawn here is that you will see in the bill those are used simultaneously because, but what you'll see there is that we're trying to maximize public participation, hence also strengthening the part of consultation in the process. So the participation part being part of those that are taken into, it's just a matter of analogy in terms of how you insulate between the two, but they are used consistently and simultaneously. Whether the issue around the Chapter 9 institution, whether we're treating this as a Chapter 9 institution, the answer is no, but because it also attained the constitutional status, it's an institution that is established by the Constitution, so hence it also accountable like any other constitutional institutions, IEC and others, to Parliament as well. So that is an alignment. So we needed to align that since it's a constitutional institution, must also be accountable in terms of the Public Finance Management Act because it's a constitutional institution and it receives funding through appropriation from Parliament like any other similar constitutional institutions. I will acknowledge where, the process where there is a proposal for members to be nominated. So there's an issue around the cross-boundary municipalities, which I think we need to insulate between the two processes. The determination of municipal boundaries in terms of the constitution must be done by an independent authority. And what we need to take into account, that must be subjected as prescribed in the Constitution through the national legislation. So where the boundary straddles a provincial boundary is now a constitutional matter. You would know in the Constitution in Section 103 provides for how the provinces are depicted geographically as provided for in the schedule. So if you want to temper or to change a provincial boundary, now you need to go through a constitutional process, no longer about this process. It means that must go through a parliamentary process and it must be voted for by the majority, two-thirds majority of parliamentarians for it to be passed, and it must be supported by 6 provincial legislatures in terms of the legislation. So it's a constitutional issue. So let's descend this process of municipal boundary to that of the provincial boundaries. It's a Section 74 bill as opposed to this Section 76 bill. It affects provincial territories or geographical boundaries of provinces. We did that before. It was done, constitutional amendment was done when Morafong was changed. I think Matatiele as well, there are various other areas that were affected in Alfred Zoo and others, which were facilitated through constitutional amendment. This was done also in 2005, where the Constitution was amended to give effect to those provincial boundary changes. Giving more power to the Demarcations Appeals Authority, because we are not trying to have a parallel structure. So if we say the Demarcations Appeals Authority should make the final decision that is binding, whether we have the authority that is given that authority to redetermine municipal boundaries, I'm not sure whether that can sit well, because at the end the board must be accountable, not so that can play as an advisory to the board to reconsider some of the decisions. The issue around the transitional cost in the measures to be provided for over a 3-year term. We've done that also, I recall in 2016 when we were dealing with the transitional arrangement measures that needed to take place when municipal boundaries, including Rand West at the time, I'm lucky that I was also part of that work when that was done. There was a transitional grant. There is a municipal demarcation transitional grant that is provided, and it was provided over a period of, the MTF period of 3 years. 450 million was appropriated for 26 municipalities for that purpose over the period of 3 years. And we also did appropriate some of the amount from the MSIG grant to assist municipalities with transitional arrangement measures. So I can say that a sufficient amount were appropriated through the appropriation in the National Division of Revenue Act. And it was explicit in terms of the conditions, in terms of how that money can be used, the rationalization of bylaws, dealing with the integration of organizational structures and other legal or labor-related issues, amongst others, finance and governance. So there are also structures that are established when municipalities are redetermined, as provided for in Section 12 of the Structures Act. So there is those committees that are established at the local level, technical level, municipal managers of those affected municipalities, including at the political level, the mayors, and it also goes to the national level where these are also dealt with when there's a transitional arrangement measures that need to take place. The socio-economic impact assessment was conducted as part of the legislative process as indicated by one of the members. That we wouldn't have reached Parliament without having that. So we do have initial socio-economic impact assessment that goes to the presidency, and they scrutinize that, and we also did the final CS that we used for introduction of the bill to Parliament and throughout the process is there. And also, we also do the other part where we submit to the Office of the State Law Advisor in the Department of Justice as well to ascertain the constitutionality and the legality of the provisions that are proposed so that we're not entering into a constitutional fray. So that structures respond also to the dedicated team assigned to deal with the transition. So I can say beyond what we have in terms of the selection panel for the appointment of board members, I can say it goes beyond those that we have indicated. It's also to guarantee independence. We also indicated that a judge of the Constitutional Court, which is also the case even now, is party to the selection panel. When board members, it's the chair, in fact, the convener that oversee from the shortlisting up to the last point of appointment to ascertain whether those people meet the requirement. And their interview, there's a lengthy interview process that they're undertaking for a person to become a board member. And there is also qualifications that are prescribed that a person must possess to be eligible to become a board member. So there is, the minister receives applications after that has been published as an advertisement, and after receiving those applications, then the convener, which is the judge designated by the of the Constitutional Court, designated by the Chief Justice, convene with also the MECs for the official from provincial department for COGTA is also part of, designated by the MEC is also part to the selection panel, and also the chairperson of the Gender Commission, the chairperson of the NCOP, or his designee, the chairperson of the Portfolio Committee. So it's also inclusive of the part of oversight of Parliament that while this process is being undertaken. So I can say the National Assembly. But we did include the traditional leadership because the boundaries also revolves around the areas of geographical leadership. The president appointing, the president does not necessarily, in practice I can say he just announces who would have been appointed through the interview process. It doesn't just go out and say, these are the people that I'm appointing. He based that through the outcome of the interview that would have been convened by those panelists that I've indicated. So then after he has received those eligible candidates that would have passed through the interview, he then appoint the board members. And that is also published in the provincial, in the government gazette for transparency. And there is a proposal that we need to also ensure that we insert their qualifications, which is part of the things that when we're responding to negotiating mandate, we are amenable to ensure that there's greater transparency. Disclosure of the decisions, we did cover that after the MDB will have pronounced on a redetermination must also publish in their website the reasons why they redetermine certain boundary to ensure that there's also greater transparency as well. And even to take it more, we're saying before they even publish the final one, they need to publish a preliminary one that will enable committees to also issue the final boundary and issue those reasons, which reasons, if the committee is not happy, can use that as part of the motivations when they submit to the tribunal for further consideration. Yeah, so the removal of integrated planning, I think the reason why the committee felt that they removed those is that it's also part of factors to be taken into consideration. So to avoid much more duplication in the repetition of that. The impact of revenue, of course, you know in our territories in South Africa, yes, we do have informal settlement, but you see even the service provisions are being provided for in those settlements. So I'm not sure whether that is a political decision because whether we write the informal settlement off or because it's a political decision around that. But we should not forget that those also forms part of the African society. And so I believe the city also have a role to ensure that we have developmental state or local government, including improving some of those areas where necessary. Thank you.
Thank you very much. Are there any additions from the provincial COGTA? Oh, okay, thank you.
Yes, thank you very much. As provincial COGTA, we're not only a government institution, but we also use the bill. So we
Please introduce yourself.
Oh, sorry. Good afternoon, honourable members, as well as colleagues from our local government officers and municipal managers that are here. My name is Jacqueline Obando, and I'm from the Department of Cooperative Governance and Traditional Affairs in the province. As I mentioned, on the 21st of March, I think it was, we submitted comments on the proposed bill. And those comments were really centered around a couple of things. It centered around public participation, municipal capacity assessment, the responsibilities of the Municipal Demarcation Board as it relates to traditional councils and areas of traditional authorities. And we also framework impedes where we are going as a province towards a Gauteng a single-tier system of governance. So those comments, I hope that they will find expression as well in the provincial mandates. And the reason why we made those comments was that Gauteng province not only applies the legislation, but also have to think about where we are and some of the pitfalls that we've experienced over the past couple of years. The bill comes to us at a very important point where we're actually seeing the Municipal Demarcation Board in action as they're doing their public participation processes. And we see that the Municipal Demarcation Board doesn't really have the expertise that we desire for public participation. The bill tries to go a little bit further than there's one salient qualification that is left in municipal ward delimitations process. It wasn't set up in time. People were expected to look at these board or maps and what impacts them on little sheets. And that's not public participation. Yes, I do understand it's the first phase, but it doesn't go far enough in terms of that. So I really do think that the comments that we listened to this morning is highly important and on board. In terms of municipal capacity assessments, what we also found was that in the assessments, municipalities don't often provide the information. The bill at the moment lacks that recourse where the Municipal Demarcation Board actually has recourse to summons a municipality to come to its chambers and then explain why they're not providing the information that is required to make important decisions around municipal powers and functions. So that's another salient point. The other one was around traditional communities. Traditional communities fall within municipal boundaries. And often, when it comes to ward delimitation, they are cut up into pieces. They're not one community. All over, when the Municipal Demarcation Board talks about traditional communities and communities, that we have to keep them together as far as possible, but yet when we go to traditional communities, you're dividing them into four pieces. So that really needs to be looked at, and over and above that, some demarcation around traditional communities needs to happen. When I talked about the impeding Gauteng's vision for a single-tier system of governance, Section 25.3 talks about what constitutes a level A, what constitutes a level B, what constitutes a level C. And as Mr. Pillay had alluded to, what we are striving to do is build our local municipalities and perhaps look at ways where district municipalities are sort of absorbed into those local municipalities rather than keeping district municipalities that are not functioning very well, that don't deliver the service much. But other than that, I think that the comments that emerged around the table today are supported by the provincial COGTA as well. The only one that we need to just rectify is that with the registered voters, despite the fact that I believe in the sentiment, registered voters, it does not sit within this legislation, but it sits within the Municipal Structures Act. There is a bigger process going on around the review of the white paper, and hopefully that can find expression in that process. Thank you.
Thank you very much for the responses from both the national and provincial departments. Honorable members, colleagues, all our stakeholders, let me thank you for coming in after you were invited, for submitting your presentations and doing all the work behind the scenes, and also for your participation and contribution. Want to also thank the officials from the departments for also coming through, and the support staff for all the work that you have really put in. So we have come to the end of the session. We really want to thank you for coming through. We're hoping that in the future, when we do invite you, you will still take these sessions seriously and come through. The next meeting will be on the 20th of May, 2025, for the Portfolio Committees at 10. The venue will be advised. I hope that you will all travel back home safely. We do have lunch on the site, so you may join us. Thank you. The meeting is adjourned.